This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court deadlocked 4-4 today in a major case over the separation of religion and government, thwarting an effort to create the nation's first faith-based charter school in Oklahoma. The tie was the result of Justice Amy Coney Barrett's recusal in the case. The Supreme Court's one-sentence order didn't reveal which justices were on which side of the divide. But during the oral arguments, it seemed apparent that 4 conservative justices were likely to side with the charter school, and the 3 liberal justices were likely to side with Oklahoma, leaving Chief Justice John Roberts as the key vote. And the chief distinguished this case from past Supreme Court decisions backing the use of public money for religious schools.
Trinity Lutheran, Espinoza, Carson, those involved fairly discrete state involvement. In Trinity Lutheran, they're going to pave put wood chips on the playground. In Espinoza, it was a tuition credit. In Carson, again, tax credits. I mean, this does strike me as a much more comprehensive involvement.
The split means the Oklahoma Supreme Court ruling that rejected the creation of St. Isidore of Seville Catholic Virtual School remains in place. And it leaves open the question of whether states with taxpayer-funded charter school programs are constitutionally required to incorporate religious institutions. Joining me is religious liberty expert Stephanie Barclay, a professor at Georgetown Law and faculty co-director at the Georgetown Center for the Constitution. How important is this case? What would the consequences have been if the court had allowed the nation's first faith-based charter school?
So there's really 2 questions there. The one question is, if the court had ruled in favor of the faith-based charter school, how important of a decision would it have been? And that would have been a landmark case. It would have been the first time that we had a faith-based charter school and would have had some significant implications, probably not just for faith-based schools and charter schools, but potentially in other states as well. Now, there's the second question, which is, okay, well, how significant is the court's decision, given that it's just, a very brief order without an opinion, 4-4 split, affirming the lower court decision? And at that point, the answer is a matter of precedent. That precedent is not particularly important. It's not going to tell us, much about anything besides the fact that they're affirming this case. There weren't 5 votes to reverse the Supreme Court in Oklahoma. And in that way, it's going to be of limited precedential effect.
Do the arguments from each side here reflect or involve the tensions between the First Amendment's 2 religion clauses?
I don't think there is a tension between the 2 religion clauses, and the Supreme Court emphasized that in its recent case in Kennedy versus Bremerton School District, that largely those clauses work together in a mutually reinforcing way. But this case does highlight the way in which you could get a different outcome under either of those clauses, depending on whether we're dealing with a private school or a government school. Because if it's a government school, then it is pretty clear that government doesn't get to run religious programs where it's preferring one type of denomination over another or setting out religious liturgy, and things like that would be prohibited under the approach to the Establishment Clause the court has been taking post-Kennedy, where it looks at the 6 historical hallmarks of an established religion. Now, if it's a private school, then the Free Exercise Clause is the relevant focus, and the question is, can the government exclude the private school? And the trajectory of cases that it has had in Trinity Lutheran, Espinoza, and Carson makes pretty clear that the court thinks the Free Exercise Clause prohibits government from excluding religious schools just on that basis. So it is a case that highlights different outcomes depending on the government versus private nature of the entity.
As you mentioned, we don't know how the justices voted. The arguments suggested perhaps that the Chief Justice was the pivotal vote who might have gone with the 3 liberals.
I think that that's probably the most likely outcome, that you had the Chief, Justice Sotomayor, Kagan, and Jackson that did not feel comfortable overruling the Oklahoma Supreme Court. And then you had the other 4 justices, Justice Thomas, Alito, Gorsuch, and Kavanaugh, that probably would have ruled to overrule the Oklahoma Supreme Court. And then, of course, Justice Barrett is recusing. So if I had to guess, and of course we don't know, but if I had to guess, I think that's what I would speculate, that the votes likely would have been. And of course, because they only got to 4-4, that means it's an automatic affirmance of the previous judgment.
The 4-4 tie was a product of Justice Amy Coney Barrett recusing herself. So since it's not a nationwide precedent, is it likely that proponents of religious charter schools will simply try again to create a school, and in a case where Justice Barrett can sit on the case?
So I think that is certainly not foreclosed by the court's opinion in this case, and a possibility at some point in the future. I think the most likely next case that you will see in the school choice movement is St. Dominic Academy versus Macon, which would be coming out of Maine. This is a Beckett case. It's possible other cases could too, but this is one that is already in the court system. And it is essentially Carson 2.0. So the same government that the Supreme Court ruled against in Carson revised their laws when the case was sent back down to try and find other creative ways to keep faith-based schools out of what is not a charter school system, but is just a traditional sort of voucher-based school choice system. And there are faith-based schools that are challenging that right now, and that's making its way through the court system. And in oral argument in St. Isidore, the justices distinguished the program in Maine, which has always included private schools and operates more like a traditional tuition voucher program, from the program in Oklahoma, creating public charter schools, where a lot of the dispute was over difficult questions related to whether charter schools are in fact private or government schools. And that sort of sticky issue just is not present in the same way in the St. Dominic case. So I think were the court to take another school choice sort of case, I think that's a more likely next step. There are no cases right now percolating that I'm aware of where there's another faith-based charter school that, has been approved or requested to be created and been denied, and that they're suing over that right now.
Has the Supreme Court in recent years expanded religious liberty rights over other rights?
I don't think that I would say they've expanded religious liberty rights over other rights, but they have certainly given a lot of attention to and been solicitous towards religious claims. And although there are certainly religious claimants that have been before the courts that didn't win their case, and this is another one. So I think this is a court that takes balanced and cautious approaches while still being sympathetic towards religious liberty claims and wanting to ensure that it's providing robust protection under our First Amendment.
We're waiting for 2 more decisions from the court in religion cases. Tell us about those.
One is a case called Mahmoud, and that is another case in the educational context coming out of Maryland. And this is a case where this school district has instituted policy where books are being read to children down to elementary school and preschool that deal with issues related to sexuality, gender identity. And there are parents who aren't objecting to those books being read broadly, but would like to be able to opt their children out. And the school in that case has said that they are not allowed to opt their children out. Their only option is to drop out of school altogether if they don't like that policy. So the Supreme Court has heard oral argument in that case, and it seems likely from oral argument that they will rule in favor of the religious parents. You have Muslim parents, Jewish parents, and Christian parents in a coalition in that case. Another case is a Catholic Charities case that the court heard before that. And that is a case where there is a question of whether a Catholic institution can qualify for tax benefit in the state. This decision from the state Supreme Court had said that if the Catholic groups were engaging in more typical religious behavior and were organized in a more typical way and were doing things like proselytizing to other individuals as part of their ministry, then they would qualify for the tax benefit. But because this Catholic charity does not proselytize and that's not part of their mission, they would serve people of their religious groups or not all alike, and they don't try and convert people to their theology. Because the Catholic ministry doesn't do that, on that basis, they don't qualify for the tax benefit. And that was another case where the court seemed quite skeptical of the government action. Justice Kagan in that case even asked, isn't it pretty clear that government doesn't get to tell people what ordinary religious practice is and which practices are approved and which are not? So, it's even possible in that case the government might be facing unanimous defeat. Certainly something is likely that they could get 8-1 or 7-2 votes in that case.
In today's Oklahoma case, were you surprised that there weren't 5 votes for the religious charter school?
I think it's unfortunate that there weren't 5 votes. I think it's possible that the chief was concerned about lack of percolation. This is the first case of its kind. There aren't other cases that have grappled with this yet. So hard to read the tea leaves about exactly what was the worry for him, but I think it's promising that this court doesn't have an opinion from the chief sort of staking it out in a way that suggests that this would be a permanent position, but leaving the door open to future challengers and future cases.
So then do you think that states that fund charter schools should be required to fund religious charter schools?
I think that if a state is operating such that they're using the label of like a government school, but they're really treating it like a voucher, then I think probably the functional analysis matters more than the labels do. But if the government is really operating charter schools like other government schools, then I think government should be entitled to make choices about running secular government schools. So it really just the devil's in the details of how is that particular government operating its school system? How much oversight is there? Is it being even-handed in the way it's approaching that oversight with, the different types of charter schools and public schools? Those are all going to be questions that will be certainly relevant to the court should a case like this arise again.
Thanks so much for joining me today. That's Professor Stephanie Barclay of Georgetown Law. Coming up next on the Bloomberg Law Show, the head of the Justice Department's Weaponization Working Group says he'll name people who the department was unable to charge in order to shame them. You're listening to Bloomberg. The Trump administration seems to be ratcheting up its use of the legal system to target the president's perceived enemies, including launching criminal investigations into New York Attorney General Letitia James and former New York Governor Andrew Cuomo. The Justice Department is also departing from its long-held policy by commenting publicly on cases that haven't been charged yet, and going one step further, promising to shame a person publicly even if there's not enough evidence to charge them. Here's Ed Martin, the new head of the DOJ's Weaponization Working Group.
There are some really bad actors, some people that did some really bad things to the American people. And if they can be charged, we'll charge them. But if they can't be charged, we will name them. And we will name them. And in a culture that respects shame, they should be people that are shamed. And that's a fact. That's the way things work.
My guest is Barbara McQuade, a professor at the University of Michigan Law School and the former U.S. Attorney for the Eastern District of Michigan. Barbara, Attorney General Pam Bondi has created this weaponization working group that seems openly to be designed to go after those that Trump claims weaponize the legal system against him. Can you explain where they're coming from here?
Well, it's difficult to know where they're coming from because it's so different from the way we have thought about the Department of Justice, at least since the Watergate era, which was 50 years ago now. I think one of the things that's most troubling to me is this memo that Attorney General Pam Bondi issued on day one, creating a weaponization working group. It takes the position that the last administration abused its power of bringing criminal prosecution and said that she was going to work to hold those people accountable. And then it names by name people like Special Counsel Jack Smith and New York Attorney General Letitia James, Manhattan District Attorney Alvin Bragg. Of course, these are all people who investigated Donald Trump in the past. And so I think this is, at first, a very significant piece of disinformation or propaganda to suggest that they did something wrong, and then to suggest that by turning the tables on them and going after them, all she's doing is evening the score and holding them accountable for their misconduct. It is an incredible distortion of the facts and the history and the traditions of the Justice Department, which, by policy, neither confirms nor denies even the existence of an investigation. So the idea that we're going to go after these people and look at them as opposed to saying, we look at conduct when it appears to violate the law, in my view, this itself is what it means to weaponize the Justice Department.
Ed Martin, the former interim D.C. U.S. Attorney, who has a new role now as head of this weaponization working group, made some remarkable statements that if they can't be charged, we'll name them. Is that ethical, and does that comport with Justice Department policy?
No. So, the Ed Martin story is in some ways a really bad story. There's parts of his story that are a good story, I think, because Donald Trump, of course, put him in place as the interim U.S. attorney in Washington, D.C., but it appeared he was not going to get the votes in the Senate, even by Senate Republicans. And so his nomination was withdrawn, and he was moved over to be the pardon attorney and to head this weaponization working group. So the good nugget there, I think, is that there is a red line for Congress that the Senate is not going to allow somebody who engages in political activity in the guise of a prosecutor from holding such an important office. So I think that's good news. But to get to your question, no, this is not at all the way prosecutors are supposed to conduct themselves. The idea that I'm going to investigate, and even if I do not find sufficient evidence of a crime, I am going to share whatever I found about you. I'm going to put your name out there because my goal is to bring you shame. So first, it is unethical for a prosecutor to make extrajudicial statements that are harmful to a person that are not within the four corners of a charging document. That's problematic. It has also been the Department of Justice policy for the past 50 years, as we said, to neither confirm nor deny the existence of an investigation so that a person's reputation will not be harmed if no charges ever materialize. And we saw this at play when Jim Comey was run out of his job as FBI director. You may recall that Donald Trump claimed that the reason that Jim Comey was fired as FBI director was because he received a memo from Rod Rosenstein, who was the deputy attorney general at the time, saying that James Comey had violated this principle when he held that press conference castigating Hillary Clinton. Even though no charges were brought, he called her extremely careless, and he complained about her publicly, which is inappropriate. Rod Rosenstein said so, many others said so at the time, and it's what cost Jim Comey his job. And now the idea that Ed Martin, in this very prominent role, is going to just use it as a place to do the same, even if there's not sufficient evidence to bring charges, is, in my view, an abuse of that position of power.
So the Justice Department has launched a criminal investigation into New York Attorney General Letitia James, who had secured a $454 million judgment against Trump and the Trump Organization. So the criminal investigation is for mortgage fraud, and the head of the FBI has already called this a case of great public importance. So they're going after her for something that has no relation to her case against Trump.
You know, in ordinary times, I would say that public officials are not above the law, and that if they have violated the law, they should expect to invite scrutiny and be held accountable. But I think in light of the track record this Trump administration has developed in the past 4 months with, this weaponization working group, especially because it names Letitia James in it, as well as President Trump's statements during the campaign that he would seek retribution, Kash Patel, the FBI director, talking about coming after political rivals and journalists, all of these things together, I think, cause us to lose confidence that the Justice Department is acting in good faith. Now, we'll see how it pans out. When you bring a criminal case, you have to have evidence. You have to prove it in a court of law, and a jury has to find guilt beyond a reasonable doubt. If they've got the evidence, then I don't have a problem with their bringing the case. But I'm really quite skeptical that they coincidentally found a criminal charge against Letitia James right after saying they were going to go after her. So it puts the Justice Department, I think, in a very dangerous place because it is supposed to be a place that is not guided by partisan politics, but by fact and law. And I worry that if they are using it or even creating the appearance that they are using it as a partisan tool, it will diminish the public reputation of the department for decades to come.
Letitia James said this week, this investigation to me is nothing more than retribution. It's baseless. Let's just suppose that it does go to trial. Is there a problem with the jury pool having been influenced by these statements by Trump and others? Also, just the damage to her reputation.
Yeah, and this is one of the things that, again, traditionally the Department of Justice is very careful about. Charging high-profile public officials requires typically high-level approvals, not because anybody is more deserving than anyone else under the law, but because of the reputational harm that will ensue, because of their inability to do their jobs, and sometimes the effect it might have on their election or re-election. And so caution should be used before raising charges about that. The fact that we know about this investigation is one of the things that so deeply troubles me. Ordinarily, as we've said a couple of times now, prosecutors neither confirm nor deny even the existence of an investigation. How do we know that there's this investigation? Well, somebody has leaked it. And that alone is problematic. Ordinarily, if you're investigating anyone, especially a prominent person, you do so quietly, secretly, and if you can't make the case, you go away. It is not the job of the Justice Department to harm the reputations of individuals, especially public figures. And in prior administrations, they went to great pains to avoid doing that.
And now we have the Justice Department reportedly opening an investigation into Andrew Cuomo, who is currently the top candidate for New York City mayor, apparently following a referral from congressional Republicans who accused him of lying during an investigation of his administration's COVID-19 response. And this comes just after the Trump Justice Department dropped the charges against Mayor Eric Adams, who will be running against Cuomo, if they both get past the primary. I mean, you talked about prior Justice Departments being concerned about the possible effects on elections.
So again, without knowing the underlying evidence, maybe there's a case there. We don't know. He made statements. Now, of course, the mere fact that you made a statement that might be inconsistent with the testimony of other witnesses is not alone a crime. You have to show that you made a false statement, that you then and there knew the statement was false at the time you were making it, and that it is material to the investigation in some way, that it matters. And so I don't know whether his efforts to make himself look better than he was really mattered in the grand scheme of things. But leaving that all aside, the merits of the case, maybe it has merits, maybe it doesn't. Number one, the fact that we know about this case is because two people familiar with the investigation revealed it to the New York Times. So it's a leak. Somebody has leaked the fact that he is under investigation. That alone, I think, is suspect. And then the point you raise about contrast this with the treatment of Eric Adams, who had been under indictment in the last administration. It was dismissed by this administration according to a judge, in exchange for cooperation in Donald Trump's policy agenda, which he called, smacks of a bargain, seems to be an effort to create leverage over Eric Adams. And so you've got that situation. It really leaves the department in a place of lacking the importance of public trust when it brings its cases. It all just seems too convenient that once again they are targeting a prominent public official whose interests they oppose. It's why the Justice Department works so hard to maintain its reputation for integrity so that when it does go on a limb and charge somebody with a serious crime, the public takes it seriously. In the past, the Justice Department has always enjoyed, in courts at least, the benefit of the doubt and the presumption of regularity. I think that's going to erode to the detriment of prosecutors and FBI agents in the future, and as a result, to the public safety of the American people. Because when a prosecutor or an FBI agent testifies in court, I think jurors are going to be far more skeptical about the accuracy of their statements than they have been in the past.
Also, President Trump defended the decision to charge New Jersey Democratic Congresswoman LaMonica McIver for a scuffle outside an ICE facility and said she was out of control.
If any other president had done this, there would have been howls of protest from the public, from the media, and rightly so, because the president is the chief executive of the entire executive branch. Anything he says can be seen as an unlawful command from the president to direct people to pursue particular angles in cases. And so as a result, most presidents are very careful to scrupulously avoid commenting on not just pending cases, but investigations, to let their Justice Department do their job based on the facts and the laws and to stay out of it. Because every time he comments on some rival who finds themselves in the crosshairs of the Department of Justice, it is creating the impression that the case is being brought for partisan political reasons, which, according to the Justice Department's principles of federal prosecution, is absolutely prohibited. And so I think it's a terrible thing. Maybe he does it out of a place of ignorance, but he's been president long enough now that he really ought to know better.
Besides, people winning these cases, is there anything that can be done about this new weaponization of the Justice Department? I mean, career attorneys are leaving in droves and others are being fired. The public integrity section has been whittled down to nothing. But is there any solution?
I don't know that there's any quick fix, and I am really worried about the long-term ramifications to the Department of Justice. Historically, it has been a plum job to be able to work for the Department of Justice. It has an honors program that is very selective and recruits out of law schools. This year, all of the students who agreed to take jobs there got their jobs cut at the very last minute, long after it was possible for them to secure other jobs, even though they would have been highly sought after if they had done so. That kind of pull the rug out from under me kind of behavior, I think, is going to cause problems in attracting and retaining top talent, which is what we would want with our Justice Department. I think running roughshod over all of these norms is going to take some time to repair. I am hopeful that we will get through this, and at some point we will have a new administration that understands how important it is to correct all of these egregious attacks on the Justice Department. But I don't think it's going to be something that gets fixed overnight, because I think once you breach the public trust, it takes a long time to repair it.
Thanks so much for joining me, Barbara. That's Professor Barbara McQuade of the University of Michigan Law School. Coming up, nationwide injunctions. This is Bloomberg. During the oral arguments over President Trump's executive orders to restrict birthright citizenship, the court's conservatives suggested they want to limit the use of so-called nationwide injunctions. But key justices voiced concerns about doing so in a way that would let Trump's planned birthright citizenship restrictions take effect before the High Court can rule on their legality. But in the Supreme Court's decision blocking Trump from sending additional Venezuelans to a Salvadoran prison, there's significant language that could provide broad relief from other administration policies, even if the justices do limit the use of nationwide injunctions. My guest is Ilya Somin, a law professor at George Mason University. Will you explain how the use of nationwide injunctions is being questioned?
So, obviously, the Trump administration wants the Supreme Court to rule that nationwide injunctions are inherently illegitimate, because in their view, courts only have jurisdiction to issue remedies for the parties actually before the court, as opposed to more universally. There are some conservative Supreme Court justices who in the past have expressed similar sentiments. Listening to the oral argument, it is unclear to me whether there might be 5 votes for that proposition, or whether instead the court might issue some sort of clarifying rules which clarify or perhaps limit nationwide injunctions, but don't get rid of them entirely.
So some of the justices seem to suggest that an alternative would be to have proposed class actions that produce the same result as a nationwide injunction. What do you think of that as an alternative?
So it's certainly much better than nothing. But as the oral argument brought out, there can be difficulties with class certification. And moreover, if we're talking about so-called putative classes, like in the AARP case that the Supreme Court decided, I think, last Friday, then a putative class, first, it has the same issues that the administration claims exist with nationwide injunctions, which is that a putative class necessarily includes people who are not parties to litigation, and a putative class is not the same thing as a real class. So at some point, if you want to get permanent as opposed to temporary relief, the court would have to decide whether the putative class can become a real class or not. And that brings back these same issues with certification.
The court then, after hearing these oral arguments, the court then continued the injunction, the temporary injunction that blocked sending Venezuelans to El Salvador. I mean, were they doing the same thing that they discussed not doing in the birthright citizenship case?
In a certain sense, they were, because that injunction, which is a temporary one, is for a putative class. And so a class that has not been actually certified and possibly may never be certified, depending on how things go. So it was definitely providing relief for non-parties, which is exactly the kind of thing that the Trump administration, says should not be permissible, and that, some Supreme Court justices have said should not be permissible. It's notable that Justice Gorsuch, who has expressed complaints about nationwide injunctions in the past, seems to have been in the majority in the AARP case. Only Thomas and Alito dissented. In theory, in a shadow docket case like this, they don't have to announce where every single individual justice stood. But I don't know for sure, obviously, but I think if there were other dissenters, we would have seen them.
Tell me about the dissent written by Alito and that Thomas joined in.
So the dissent raises a number of points which are not really related to nationwide injunctions or class actions, but one argument that he argues at length is that he doesn't think that class certification should be permissible in a case like that, and therefore, by implication, you shouldn't have a putative class either.
In that decision, there's language sort of encouraging using putative class actions in these cases.
So I don't know that you can really point to specific language, but the very fact that the court did what it did should be encouraging new advocates of putative classes in that, they allowed the putative class to go forward, and they even did sort of an emergency intervention to enable it to do so. And, that's not a conclusive determination, but it's a fairly strong signal, I think, that there's a majority in the Supreme Court that is willing to accept putative classes, at least in some situations. So again, I emphasize a putative class is not ultimately the same thing as a real class.
I wonder why the Supreme Court decided to take the birthright citizenship case and, hear arguments on it, when it seems to be one of the cases that proves that if you're ever going to have nationwide injunctions, that would be the case where you would have them, because otherwise there'll be different rules in different parts of the country about whether babies are citizens.
So in my case, you're preaching to the converted on that. I think there are two possible theories, perhaps more than two, but two that occur to me as to why the Supreme Court took the case. Which of them is true, I do not know. One possibility is if you posit that there's a faction that just wants to end nationwide injunctions, then, doing it in a case which is sort of the best case scenario for supporters of those kind of injunctions, that would show like we really mean it when we say there should be no nationwide injunctions. That's one possibility. The other possibility is you can imagine that the four justices it takes four to take a case who wanted to take this one did so because they're actually in favor of nationwide injunctions and want a precedent saying that, and this would be a good sort of sympathetic case in which to do that. So those are two possible theories. Which is true, I do not know. If you have inside sources that can tell you which is true, I would be happy to find out myself.
So you already have a federal district judge who cited the language in that May 16th ruling to temporarily certify a class of alleged Venezuelan gang members. So once one federal judge does so, others will likely follow.
Yeah, so I think it's fairly obvious that if the Supreme Court was willing to essentially bless this kind of arrangement in this case, that it can also be done in other cases. I suspect this judge will not be the last to do it. Obviously, the Supreme Court did not give us a lot of clarity on exactly when putative classes are permitted and when they're not, for how long they're permitted, and so on. And those issues may well have to be litigated in future cases in the lower courts and perhaps also in the Supreme Court. But the basic idea of putative classes, it seems like there are 7 Supreme Court justices who are okay with it, at least in some instances, and lower court judges are not stupid. They can see that.
So what's your take on nationwide injunctions?
So I agree with what you said earlier, which is that they're a valuable tool in cases like the birthright citizenship case, where you have nationwide illegality. The reasons why the government action is illegal do not vary from place to place or from case to case. They're uniform. And the rights of many thousands of people may be at stake, and it might be difficult or impossible for all of them to bring their own individual actions. There might be. And so it seems to me that nationwide illegality requires a nationwide response. At least in some cases, nationwide injunctions are the appropriate response. I do not agree with sort of the concern on the other side that, well, a rogue district judge can block a policy for the entire country. If he's truly a rogue and his or her reasoning is really bad, it can be quickly overturned by an appellate court. An appellate court, you have procedures for dealing with these kinds of cases on an expedited basis.
So we will see by July whether the Supreme Court actually makes a move to restrict nationwide injunctions. Thanks so much for joining me. That's Professor Ilya Somin of George Mason University. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.